viewers, welcome to this edition of a TFN News Review. I am Sergio Brito. In today's edition, Bob Keita's rape trial continues in court. We'll be bringing you what happened in court and the protest of Bob's supporters who marched in protest from the High Court in Banjul to the Mile 2 prisons. Women gardeners in Bakau explained to the Fatu Network their challenges amid countless pleas for help. As heavy downpour continues in some parts of the country causing disturbances, the Fatu Network has engaged the director of the National Disaster Management Agency on a range of disaster mitigation issues. We have an exclusive on that for you as well. We'll be later joined by lawyer Melville Robertson, someone who has been following the Bob Keita case away from home. All of these and more coming up shortly after the break. Stay tuned. Welcome back. Justice SM Jallo of the Bundung High Court has dismissed the motion of lawyer LS Camara, defense lawyer representing Bob Keita in his ongoing rape trial. The motion was made by lawyer Camara to set aside the court order of the 7th July 2022 to conduct a DNA test. More in this report.
As the hearing of Bob Keita's alleged rape trial resumes at the Banjul High Court, Justice SM Jallo of the Bundung High Court, who has been the presiding judge of the case, has today, July 27, 2022, dismissed the motion filed by the accused lawyer LS Camara, in which the defendant seeks the court to set aside the court order of the 7th July 2022, which ordered for a DNA test be conducted on his client. While delivering his ruling on the defense's motion, the judge said the motion dated 18th of July is seen as an abuse of the court's processes and therefore dismissed it. Going further, saying that if the court gives orders, it expects compliance. This is because the court, as SM ruled, has adopted the 22-paragraph affidavit of the prosecution dated 20th July 2022, opposing the defense's motion of setting aside the DNA test. Justice Jallo reiterated that the state has been charged with the responsibility of supervision and coordination of the DNA test and asked the defense counsel to cooperate and ensure the requirements are met in time. He advised the defense to submit to the DNA test while requesting the authorities to take a sample from baby Mohammed in the presence of the defense to ensure a transparent process that will satisfy the defense. The state counsels were satisfied with the ruling. However, the defense counsel, LS Camara, said they will appeal the ruling. The judge told the defense counsel to prepare for their defense as the matter is adjourned to the 5th October 2022. LS Camara rose to tell the judge they were ready to proceed with the defense during the vacation, saying they have the accused and 2 other witnesses they could proceed with. But Justice SM replied that he is not the vacation judge, and if the defense was ready to do so, they could make arrangements and proceed with the vacation judge. Reporting for the Fatu Network, I am Usman Sedikan. As the hearing.
On the same Bob Keita's case, sympathizers of Bob today marched in protest from the High Court in Banjul to the Mile 2 prisons where Bob is being held in custody. Here is an excerpt on that.
Well, viewers, these are the family members of Bob Keita. You can see the expression from their face. They are crying. They are not happy with the ruling that the judge has given. This is Bob Keita coming out from the court. They are taking him back to the court.
Frustration, it brings about anger, and we can understand. You have your loved one being locked up, in jail for so long, and you don't understand why. So the right thing to do is just to be frustrated, to be angry, and some people cannot really deal with it. They express it. And I'm just saying that no matter what happens, just express it in a good way, not to infringe on anybody's rights as well.
Until nata Keita nyela Bob la court mbela kala mutanyonna nata wala bara ketanye disappointment oti bake me alan ka foko kata jojo la ruling time menke bi disappoint alale in a sense that Kito nyi ameta la sai be me expecting bi wala mu fente me alan ka foko membe Kito nyi tariandila for the next season na mo banya next season nya nyanta ka banne but bi jojo la bi ruling bi aketa nya fente me alan ka foko disappoint in a sense that feme alan ka folo mu DNA test atata wato menna a conditional min tata kam melan ka fani loi fota nyon komale oto loi nyanta la doko kala mari nyil kanne but I wonder why loi mala doko kol kan fuka na muru ko take ka fuko take again DNA test have to be retested again pour kana nyon ko to kan disappointment baldi
jamur ko innocent 2 years nga remain ko ko do am dara do am legi ñu ñëwaat ngeen wa another 3 months niki wérut yow bop du dé dem sax dem ben du dé am ben medical treatment du dem defi ben medical check up bob soko gisee right now ben tankay mi ngi so pour lan yow yaangi am dom yaangi am jabar yaangi am family pour lan dafa opa nit ñi dañ am nahar nañ bay doomi jambour bi mu dem nañ ko bay mu dem te li fu mu nekk ni daf ñoo lead fo xamantene ken xamut
sympathizers and supporters of the accused person are here chanting justice for baby M and also justice for the accused person who is Abubakar Bob Keita. To the entrance of the prison here, we are at the State Central Prison entrance.
Welcome back, viewers. Now I will be joined by a legal practitioner, Melville Robertson, who's also been someone who's been following the Bob Keita case away from home. Melville is joining us live there. Melville, can you hear us? Welcome to the Fatu Network.
Okay, sorry, my microphone was on mute. Can you hear me now? Yeah.
To the Fatu Network News Review, Melville.
Good evening. Thanks for having me. I'm glad to join you on your news review program for the first time.
Thank you very much. Just to go straight to the point, you are a lawyer. And like always, you know, we can't discuss the substance of this case because it is obviously before the court. Going by what some people describe as an unprecedented rape trial in the history of the Gambia, what is your take so far about this whole Bob Keita versus the state case?
Yes, it is unprecedented for the simple fact that this trial, Bob Keita, the state versus Bob Keita case, what it has done is that it has exposed the criminal justice system of the Gambia. It has exposed the judicial system of the Gambia to the outside world and to the entire nation. There has never been a time where you have a criminal matter of such nature that has generated such public interest, both in and outside the country. And the reason for this is because of, obviously, one is the slow pace of the trial, because if you can tell, this trial has been ongoing for over 2 years, and it didn't generate such public interest as it is now. But there's a lot of things that are very peculiar to this case. One is the fact that the most substantive part of the heart of the criminal trial, which is the baby that was allegedly born out of the alleged act or offense of the accused person, mysteriously died in circumstances that nobody can actually pinpoint, in very mysterious circumstances. So that again invoked public interest in this matter, because it was a situation whereby people felt that this particular matter had involved 2 minors. So aside of the fact that it exposed the criminal justice system, it exposed other institutions of the state that were very lackadaisical in their approach to this matter. So, for example, you had 2 minors that were involved. You had the alleged accused person who was a minor at the time of the offense, and then you have the baby that was born out of the alleged offense, who was also a minor. And you could see there was no interest in ensuring that these two minors were protected by the state, by competent authorities that were responsible and vested with such. So all of that, coupled with the slow pace of the trial, and coupled with the fact that you have seen the trial dragged, and of course it came out where the trial has been adjourned for over 33 times at the instance of the judicial officer, at the instance of the presiding judge, and some of the reasons for this adjournment were very flimsy, and so you tell that there's a public outcry, and that is why this matter is radically different from every other matter.
About the protection of the two minors, can you just enlighten us? What kind of protection did you expect the relevant authorities to give to these two people?
Okay, for example, if you look at the circumstances, I mean, like we're not delving into the substantive matter of the case, which is meant for determination, but the facts are very obvious. The facts are not secret. The facts are public knowledge. Now, you have a minor who is the alleged victim. And this minor was in the custody of an adult. So the alleged crime occurred whilst this minor was ordinarily within the legal custody of another adult. And then this alleged crime occurred. So one, that should have been a red flag that this minor, something has occurred that's radically not right with the child. And therefore, there should have been the need for either the Child Protection Alliance or the social welfare to work on ways whereby this particular minor, even though is the legal guardian or whoever she was with was her sister, would actually some sort of interest in this matter. Because one, no matter how you see it, it might appear to some, okay, you can't put the blame, you can't point blames, you can't point fingers. But the fact is, a liability has to be someone, and that is the sister who failed in one way or another, either by action or omission, to protect this child and allow this child to be victimized. Because regardless, if we're not delving into the substantive matter of the case, but remember, this child is at the time of the offense was 15 years old, and if you go by the Sexual Offences Act 2013, at any child who is 16 years and under that lacks the capacity to grant or gives consent of such nature. So you could tell that obviously a crime has occurred because that child was pregnant. So therefore it means that statutory rape has occurred because someone had carnal knowledge or someone had sexual intercourse with the child that led to the child becoming pregnant. So there is a failure in that. The second part is that this child, a minor, now was delivered of a baby. So the minor was now having to protect and having the care of another minor. And this is where the Child Protection Alliance should step in. So I saw a press release where they are asking the government to investigate. They're asking the government to take steps. But they are very slow. The Child Protection Alliance does not have the legal mandate to start questioning state authorities to investigate crimes. Their foremost mandate is the protection of children. So they should have been at the forefront. They should have been there to protect these kids. They should have been there to ensure that both the minor becoming the mother and the child that was born were adequately cared for, and some sort of protection, a protection order either from the court at the instance of the state or the defense should have been advanced to secure the interests of these two minors.
And now perhaps one of the most significant thing as far as this case is concerned, the DNA motion of the defense counsel, that is Bob's lawyer, has been dismissed by the court. What does such dismissal generally mean for the defense counsel and his client?
Well, there are two things. It depends on what side of the spectrum you are and how you look at it. Now, you can look at it from two angles. Well, one, the angle is that I think the dismissal is fatal. In the sense that legally, I wouldn't expect that such a sample that was not done on the instance of a court order. Remember, this sample was taken before the court order was issued. And then the presiding judge went on to say that he was satisfied that the state has complied with his order by obtaining this blood sample. That, to me, doesn't add up, because the state could not have satisfied an order that did not exist. So when the samples were being taken, there was no order, and therefore, when the presiding judge in his ruling of the 7th of July stated absolutely that he was very satisfied in the way and manner that this blood samples was taken, and that he believed that the state had complied with the order of the court. That for me was problematic, because there was no order. So what the state was complying with was not an order of the court. And secondly, if you look at it from the deliberations that took place in court, the state was never party to the collection of the samples. The state informed the court on the 8th of July that they were unable, or it would be problematic, to comply with the court order because the child was ill, and they have been informed that the child was unconscious and the child was away in Senegal. And then we saw a few days after the state coming to court and explaining and passionately making an advancement that yes, the court order has been complied to. So that again is problematic in this matter, because you're wondering what court order and what was complied on. This is a highly contentious matter. The life of an allegedly accused person is on the line. This is a person who has been in jail for about 2 years. You cannot possibly take a blood sample in such a contentious matter where the defense was not present. There was no independent body present, and I dare say the state was not even present when these blood samples were taken. So that order is problematic in that regard. The second angle is that one can say that the judge today has overruled the application from the defense to set aside that order. Now, if you look at it at another angle, you could say that fine, let the proceedings go on, and this would be an absolute good ground of appeal if the matter is decided against the defendant. But when you look at that problem and that as well, what it tells you is that the accused person will continue to languish in jail, because at the eventual outcome of this matter, then of course this is grounds of appeal. So it would mean it would have to go to the appeal court, and if it's already
perhaps because you just mentioned that the accused person will probably be languishing in jail, and I just want you to kind of like clarify that part, because most of the time when you meet with people, especially sympathizers of the accused person, they tell you that we are demanding for him to be released immediately. From a legal perspective, can you explain to us how when you are accused and charged of rape, that it is unbailable according to the constitution of this country? Perhaps we need to make that part clear. I know I've said this during the live video on Monday, and someone said, oh, she is supporting the lady. But can you, from a legal perspective, can you please explain that part?
Well, one, I do not agree that the constitution states that the offense of rape is not bailable. One, I don't believe that. The CPC section 99, most people rely on, that the offense of rape, because it is a capital offense, it attracts the penalty of life imprisonment. Therefore, life imprisonment and death and such offenses are not bailable. However, if you also look at the CPC, you will get to realize that the CPC has left the issue of bail to the discretion of judges. Bail is in the hands of the judges, depending on the circumstances and peculiarity of the case. Now, I know a lot of people are saying that rape is not bailable, but I can assure you that until 2 months ago, rape accused persons are being granted bail by the High Court of the Gambia. And this matter, this issue of bail, remember Bob Keita was granted bail by the High Court. He was granted bail. The state appealed, and it was revoked by the Court of Appeal. Now, the Court of Appeal is not the apex court in the Gambia. You would agree with me that the Supreme Court is the apex court. So this matter has not been tested. The issue of bail or rape victims or capital offenses has not been tested at the Supreme Court. I know as a matter of fact that the Court of Appeal, it was just one panel of the Court of Appeal that sat on this. You could have another panel of the Court of Appeal come to a radically different conclusion, and you could have the Supreme Court come to an absolutely different conclusion. So until the Supreme Court adjudicates on this, it is not gospel that rape accused persons are not and cannot be granted bail.
We've seen this case adjourned over.
Let me also say this, because I think it is very important for people to understand. Now, even though the CPC provides and states that the sentence of a convicted rapist is life imprisonment, it goes further to leave discretion in the hands of the judge when it comes to sentencing. So if you look at the court, Sergeant, I'm sure you have seen where people have been found guilty of rape, but they were not necessarily sentenced to life imprisonment. So that is left discretion of the judges. And therefore, you could make a legal argument that if that discretion is there, where the victim will not necessarily be subjected to the life imprisonment or death sentence or whatever it is, therefore, it will ordinarily mean that discretion of bail is also left in the hands of the judges.
And now, to this case being adjourned over 30 times and has been in the court for almost 2 years now, garnered so much attention both locally and internationally. Is this something that is normal?
It is the norm. It is the norm in the Gambia. If you go to remand, you will see accused persons that have been there without trial for 6-7 years. I know of an accused person who has been in remand for 7 years to 8 years and has just now been released, because I think the court held that, the time that he has spent in remand alone was sufficient for the crime that he was accused of, or something like that. Some ruling to that effect. So if you go to remand, you will see a host of accused persons who are behind bars, who have been there, and they are languishing. And remember, it's not every accused person that is in remand. That's the focus of Bob Keita. There are so many people that are not necessarily the Bob Keitas. They don't have the friends like Melville. They don't have the reporters and correspondents like Sadio taking interest in that matter. And they continue to languish in jail. A criminal justice system has failed these accused persons and have also failed the alleged victim, because the victims are unable to find any sort of closure, any sort of answers to their claims or their complaints. So the criminal justice system is not only abusive to the alleged accused person, but it is also not fair to the victim. However, because the alleged person is the one that is faced with incarceration, is the one that is behind bars, it is the one that is the person that has had his rights curtailed, he has and bears the greatest brunt of the effects of the ineffectiveness of the criminal justice system in the Gambia.
Another legal practitioner, Aziz Bensouda to be specific, who says adjournment of criminal cases for a summer vacation is not legal. Can you take us through the legality and the illegality of this supposed summer vacation that the judges are talking about?
Well, if you give me a moment, I'll just read it out for you so you get to understand exactly where Aziz was coming from. And I think he is absolutely right. And sorry, I was just trying to see if I can get that so I can just read it out for the benefit of your audience. So if you just give me 1 second, I'll just go to it. So it reads, and this is Order 4, Rule 5 of the High Court rules. And I will read number 5, section 5. It says, matters dealt with in vacation. It shall not be necessary for the High Court to sit during any period declared by this order to be a vacation, except for the trial or disposal of criminal causes or matters, or such other causes or matters as may by this order be declared to be causes or matters which may be tried or disposed of during the vacation. So it is clear that the High Court, according to the rules of the High Court, which are complementary to the High Court Act, are saying that, yes, there are 3 instances where the courts have vacation, and that is Easter, Christmas, and summer vacations. But there's an exception to this vacation. The High Court rules deem that where a criminal matter is involved, the High Court does not necessarily have to go on vacation, where the life of a person is on the line. So in instances of criminal matters, the courts do not have the discretion of going on holiday. And this is what Aziz was trying to say. But it has been a practice, it has been where the courts would just get up on holidays, regardless of the matter that they're handling, and judges would just go. But what Aziz was trying to point out was the adjournment of such a highly contentious matter, a matter of such public interest, both nationally and outside, should not have been adjourned to October. Whereas the judges had legal discretion to go on vacation, a matter of such public interest, a matter that is a borderline on national security, no judge should have been able to adjourn such a matter till October. So what Aziz was trying to point out was, even though the adjournment was done, that adjournment was illegal, because in issues of criminal matters, the courts do not have the leeway to go on vacation. It is not left with the discretion of the judges to go on vacation where a criminal matter is on. In fact, if you look at the CPC, which is the Criminal Procedure Code, section 162, it says where instances where an accused person is before the court cannot ordinarily adjourn for more than 15 days. And where the accused person is in remand behind bars, they cannot necessarily adjourn for more than 7 days. So you could tell that both the actions of the judge today, it has violated both the High Court rules, the CPC, and the Courts Act. But this is something that is common. It is something that is being done, that was never challenged. Well, it's frowned upon, but nothing has been done about it. But what would have expected, where the criminal justice system, where the judicial systems are on the line, every single eye and attention is focused on them, you would never have expected such lackadaisical actions to be taken by the judge.
And in a related case, Senabu Mbai, the ex-wife of Bob Keita, is standing trial for manslaughter. Now, before she was charged, there were rumors that she was going to be charged with conspiracy and manslaughter. And then 2 days later, the charges were changed. As a matter of fact, you did a very, interesting live video explaining that you cannot have manslaughter and conspiracy on the same charge sheet. Can you take us through that?
Yes, because what was rumored was that the police were going to charge Seinabu and her brothers for the first charge would have been conspiracy to commit manslaughter and manslaughter. Manslaughter is an accidental death. The distinction between manslaughter and murder is that murder is premeditated. Murder is held to have it contains and possesses the mens rea, the mind, the thought process. It's something you think about, it's something you plan. And therefore the distinction between murder and manslaughter, because both occasion a loss of life, but one is accidental and one is premeditated. Now, what I was trying to argue is that you cannot conspire, because when you conspire, you plan. When you plan, it involves the thought process. When you plan, it involves the mens rea. So you cannot have a thought process where you plan to commit an accident. You can only plan to commit a murder. So if you plan and your plan is executed, and that execution leads to the death of a person, the charges can only be murder and not manslaughter. So this was my argument, because such a charge sheet, if it was gone before the courts, it will totally fail, because the two completely at odds with each other. You cannot conspire to commit something that is ordinarily an accident. So that was my argument. And then eventually when we got to court, we realized that the police or whoever dropped that charges of conspiracy to commit manslaughter, and the charges of manslaughter was upheld. And now manslaughter is also a capital offense where it attracts life imprisonment. And therefore, again, using the same argument that we mentioned with regards to the CPC section 99, where it mentions that offenses of such nature are not bailable, and therefore the magistrate's court did not have the jurisdiction, one, to hear the offense because it was a capital offense, and could not have granted bail because they lacked jurisdiction. And therefore, she was remanded at the 2 Central Prison awaiting trial.
And finally, before I let you go, Melville, what do these two cases mean for the Gambian justice system? Well,
these two cases, again, have put a great focus on the Gambian justice system. And now these two cases are at par with each other. So now you see where one criminal trial has already been adjourned to October. Now, people will be looking, the general public will want to know and see whether the trial of Sainabu will now hold, whilst Bob has been sent to Mile 2 to wait for another 3 months. But again, people, the public would have to be, amply sensitized, because as far as I know, as far as my knowledge takes me, and from the information I've gotten, is the defense counsel for Sainabu have already made an application for a certificate of urgency to say that this matter is urgent and therefore must be heard before the vacation judge. And a trial date of the 3rd of August has already been set. Now you have Bob Keita on the other side, who I expect, I've spoken to his lawyers as well, and I'm authoritatively say that the lawyers are also going to make an application for certificate of urgency to have his matter continued with the vacation judge. But these two cases have put a spotlight on our criminal justice delivery system, where people are going to watch. People are going to watch whether the same measure, the same yardstick that was used in the Bob Keita trial is the same yardstick that would be used in the Sainabu Mbai trial. So it is a situation where you have parallel criminal trial going on. The spotlight is on both cases, because remember, the victim in the manslaughter trial was the victim in the heart of the Bob Keita trial, and therefore this has invoked much public attention, and rightly so, because even anywhere in the world where a victim of such importance to the court, of such importance to the outcome of the case, is suddenly died in very mysterious circumstances. Anywhere else in the world, there would have been room for doubts. There would have been room for speculations. And of course, an investigation would have been needed.
Thank you very much, Melville.
You're welcome, Simon. Thanks for having me.
Thank you very much. We will continue following these two stories. Away from that, women gardeners in Bakau have explained to the Fatu Network their challenges. The women cry out that no one has come to their aid as they are confronted with many challenges. More in this report.
Like many countries, the Gambia heavily depends on agriculture for both consumption and economic growth. A bulk of farmers in the country still practice subsistence farming, which is restricted to only provide food for a farmer's family. Women farmers in Bakau share with this medium their challenges. According to them, pests and diseases affect their crops. They also cited the lack of water supply as a major challenge. The women urged government to help them realize good harvest. Binta Conte explained the major challenges they are currently faced with.
Kadino Raja, Giamunya Kolea Kulet, and in Jambando. We feel for an abong, Birum Kuifula. Nka pompo dati wolt nsi pompo kala ngake fo malam ben kala nyama o posino fanan kambatan di jambaki nyim fen nano wala mun nakola yakut.
Another farmer, Alima Bojan, disclosed that the ongoing OIC road project adversely affects their work.
Ndol kadu ko kay nyindula mente bota jeten ndol la kenol be jelen ndol be bota wolot mbelu wolto do ko samati kan en kambalu jelen kan di bari natam bondi jele ko kana silo do ko yo sila do kula man na wol man futam ma bari after nata keno nyi mo na tambo ni je comme e kana je sa en to bota je nta ko mom mo bari nyina en ta fonde na ko parce que na ko nta ka jabo men soto je nta fono ka so mon soto ja siat bari nyina nta en fonde na ko ka to man do ko la sot janna jaba buka keno je ku chalen jato men taw bari jabol ni super mon ko be do ko jal bari nyina ante de akatante ko la andu akatan ni nyon jamale ko ya kot keno be la na man do ko ndol man do ko la do sot nka ku cha do ko jal na man ko tinal benta ku caaja mo men kuntu sainte ko bar sainte o fana beta nata beta nyin karo fo kar kota ita do ko fen sotol e bu ka fen sotol be me wafle bu ka fen sotol be do ko ka element sa yalo mun ñokola ya lalat wala mun na problem motija.
Masira Jame noted that they don't have model tools to make their work easy.
Saje kolon te sa sing ngata suwo kono tabiro jannin kana ngata boyta uto boy nya nara na fero fana sot isi bere me sango duni na yaduni o yorondo fon hani simente kolon bute ko bere me sango le ta e simento sa e tidi bon ko jo ako simento le nyoka lo nyoka ay na bula kolon kana jindi ni ngala manta be a jindi dula na katita buliji ila ko do los fana be katita le ka lo so fana fe ye simenti do fana sa ina ta yaf kolon kilo kan charge nimbo de dala wuli fule ko kolon kilo jo wala ha cement kolon kilo bare banku kolon on te fenti jang ita musuto on te men suto fanka kolon sinja ngata so kono tabiro jani kana ngata boyta bidin o boyo jube na lo nyim bere me sango ko bere me sango ko na nakana nkalo cement kolon te jang ni ngalo cement kondo ni telefona mbo jindi la no fana 14 tete ka akatita doro itela lo sumo fana fo la do fana jibe ko tanke yasi o hanna bulata kolon ko to kono o fana boka bete ya alon ko bidula do fana jibe le yasi ti kando ji ko de akambatande jane kende ken anda mal fanka to sonkala nyoy janji ko la.
The farmers cried out that no one has ever come to their help, saying that they feed their families and pay their children's school fees through gardening. Women are still set to dominate in small-scale agriculture in the Gambia. Reporting for the Fatu Network, I am Karimati Jallo.
Welcome back. Let us now take a look at some news happening elsewhere. French President Emmanuel Macron has strongly criticized African leaders' response to the Ukraine war during a press conference in Yaoundé. Mr. Macron hit out at the hypocrisy, particularly on the African continent, that denied the Ukraine conflict was a war. Some African countries have held back from outright criticism or criticizing Russia's aggression in Ukraine. In March 17, African countries abstained in a UN vote to condemn the invasion. Also, 9 people have died following a suicide explosion in the Somali coastal town of Marka in the regional capital of Lower Shebelle. Reports indicate there could be multiple casualties from the blast that happened outside the district. The Al-Shabaab military group said it carried out the attack that killed District Commissioner Abdullahi Wafau and some of his security guards. Marka town is situated 90 kilometers south of the capital, Mogadishu. This is where we bring the curtains down, but let's leave you with an exclusive interview with the director of the National Disaster Management Agency as he speaks on a range of disaster mitigation issues. Thank you very much.
Well, good morning. Good morning.
Morning.
Hello viewers, thank you very much once again. My name is Dauda Balde. To remind you that you are watching the Fatu Network Live. We are broadcasting at the National Disaster Management Agency office in Kanifing. In this special interview, we'll bring you about insights about the mandate of the National Disaster Management Agency and also the challenges and the preparations. As you all know, we are already in the rainy season. And here is Executive Director of the National Disaster Management Agency, Sana Dahaba. He will take us through the mandate and some other areas as far as disaster is concerned. As it is official always to start with introduction, and my name is Dauda Balde. I work for the Fatu Network. You can introduce yourself.
Thank you very much, Mr. Balde. I am Sana Dahaba. I'm the Executive Director of National Disaster Management Agency.
Well, Mr. Dahaba, now that we are already in the rainy season and the reports are trending on social media that there are floods in some parts of the country, though no major damage has been recorded for the meantime. Now, what plans is your institution putting in place to ensure that this flood is mitigated in the country and other disasters as far as this rainy season is concerned?
Thank you very much. If you look at what's happening now, National Disaster Management is responsible for all kinds of disaster. But we work with our partners, our stakeholders. The flood we are experiencing now is as a result of unregulated housing and due to all the compliance and enforcement issues. You can see some of the flood-prone area people have been constructing infrastructure on waterways, and that's really causing serious flooding as of now. The other aspect is that unregulated housing. Other one is an issue of compliance. You can see anti-littering law is in place, but how many of us are really observing that? You can see people are illegal dumping everywhere, and these are things that induce flooding. So I think from a regulatory point of view, National Disaster Management is working with the partners to make sure that we enforce those kind of aspects. The biggest challenge that the people have in this country is attitude. I think as long as we don't change our attitude, the attitude problem will continue to pose a serious threat to even our national development. This is what we are actually experiencing at the moment.
Well, you talk about here constructing houses in waterways, and I believe that is the work of the physical planning, who should guide people when constructing houses. What is your relationship between the physical planning and also the KMC with regards to illegal dumping that is also affecting waterways in the country?
Well, illegal dumping, some of these things happen at night. The KMC has very limited control over this. Anti-littering law is in place, but has it been seriously enforced? I think that's the problem. With regard to constructing on waterways, some of these developments are unplanned for, and physical planning. If you look at it, like what I keep telling you, compliance is an issue. How many of us goes to physical planning and ask for a building permit? We don't do it. If you don't do these things has a serious negative effect when you do certain constructions in certain places. This is what physical planning needs to enforce, that nobody should construct any infrastructure if you don't have a permit, because it may actually, water will always find its way, come what may. So as long as it's raining, water will always find its way. So this is what the agency is experiencing as a serious challenge at the moment.
Well, with regards to this attitude, people's attitude towards certain issues, we understand that we have laws in this country. A series of laws when it comes to enforcement is a problem, and also now we are talking about people's attitude that is also leading to disaster that can be prevented. So what is your collaboration with the Gambia Police Force to ensure that some of these laws are being implemented to citizens who doesn't adhere to this?
You see, the best form of disaster mitigation is awareness creation. People need to be sensitized. People need to be conscious of what's happening, especially with their environment. As an agency, this is a continuous process. Sensitization is a continuous process. But as long as sensitization is a continuous problem, the general public must also comply with the law in terms of anti-littering law. As long as we don't change our attitudes in this country, national development will continue to be a serious challenge, and such things are going to be a serious threat to our national development.
Just recently, last month, the Gambia weather forecast, they just predicted that this year the rain season will go longer than expected, meaning we will have more rain than the previous ones. So what are some of your constraints with regards to this? And now you are talking about people's attitude, and also there are many other issues that are factors contributing towards this. What are some of your constraints?
Well, actually, it's not a constraint. Operationally, we are working with the council to make sure that we clean gutters. We make sure that we actually provide the right information to the public, as the first step of mitigation is awareness creation. We are actually doing that. But we have a limit as far as NDMA is concerned in terms of resources. We all know COVID-19 has actually caused serious problem in African countries in terms of our resources, coupled with the Ukraine war and so on. But NDMA is doing everything within its capacity to make sure that we address some of these flooding issues, because as of now, we are engaging with the KMC. We are working with other councils to make sure that this flood areas, we reduce the impact on the population.
When we
supplement other donors.
We talk about now government is being supporting the primary duty bearer, and now the main